We'll call People versus Austin Wright, 25 CR 1212. I'll take appearances. Ms. Raines.
Morning, Your Honor. Katie Raines on behalf of the people.
Thank you. And sir, if you'd say your full name, please.
I am the living, breathing man, Austin James Wright, Jr.
Mr. Wright, I will consider that you have entered your appearance. I will say that I acknowledge your non-conventional entry each time requested. I don't know if that's an attempt to lodge an attempt at a sovereign citizen entry to suggest that the court does not have jurisdiction over you. I will simply let you know if at any time I'm not aware of whether or not Austin Wright is present, I will have to issue a warrant for his arrest. I acknowledge your appearance, Mr. Wright. You have entered that appearance. There is no need for such a warrant this morning. Good morning to you and Ms. Raines. We're set for motions, and the reason the court set this motions, and it was an additional motion setting because the court wanted to make very clear to Mr. Wright that we were set for this motions and that the court wanted to clarify any motions filing deadline and the court's deadline for any plea cutoff. I acknowledge Mr. Wright's previous filing as it relates Mr. Wright, you filed a motion on August 4, 2025, and the court previously ruled on that. I acknowledge it just once again because the court recognizes that there have not been additional filings since then. The court recognizes the motion is based on a concept of corpus delicti. The court's already ruled, and Ms. Raines, let me look to you and ask you just to bring me up to speed on status, and I'll give Mr. Wright the same opportunity.
Yes, Your Honor. An offer has been extended. I can make a LAFA record. My understanding is that Mr. Wright does not wish to accept the plea offer and wishes to have a jury trial.
Mr. Wright, is that your understanding? Is that what you don't want to accept the offer and you want to go to trial? It is your right. I'm just making sure to clarify.
Well, there's a bunch of things that I have questions about.
Welcome to court, where reality meets internet mythology. Today's case features a self-described sovereign citizen grandpa facing 8 charges, including 2 felonies, after rejecting a surprisingly generous plea deal. The judge calls the case, appearances are taken, and the defendant introduces himself as a living, breathing man. That phrase alone tells you this hearing is about to get spicy. Buckle up. Legal theater is officially in session.
Are those questions that you think you might wish to ask a lawyer? All right. Are there just personal questions that you are contemplating in your mind, or the questions you wish to ask Ms. Raines or the court?
Questions I'd like to ask her.
All right.
On the record.
Well, I can't be part of your negotiations with...
It's not a negotiation.
Help me understand, for example, what you're
trying to...
Mr. Wright, hold on. We're going to talk one at a time. And so help me understand the nature of the questions you'd like to ask Ms. Raines.
The nature and cause of this action.
Mr. Wright, have you received the discovery in this case? Those are the police reports.
Some of them I still have. I was called yesterday that there's more discovery that I have to pick up.
All right.
Today.
Ms. Raines, any record on Mr. Wright's obtaining the discovery in this case?
I actually don't have a note from our discovery department about whether he did pick up the initial batch. I can tell the court there are, I think, 2 new documents. One is a CV for a crime scene analyst who fired a weapon, and another is a criminal history for the traffic victim in the case. The rest of the reports should have been available to him, and so if he did pick up initial discovery, he should have all of those initial police reports.
All right. So, Mr. Wright, I'll let you speak with Ms. Rains. I'm not going to facilitate a discussion. I've given you an opportunity to file motions for me to entertain today. What I'm going...
I filed a motion, sir, and you set a hearing for it, and it was never heard, and you denied it. So I understand that I don't get a fair hearing here in this court.
The judge acknowledges the unusual introduction, but issues a firm warning. If the court can't clearly confirm who's present, an arrest warrant could follow. Translation: word games won't override courtroom procedure. The judge clarifies motion deadlines and confirms a previously denied motion based on corpus delicti. In plain terms, the court already ruled on it. No remix, no encore, no viral loophole.
And I also would like to know the financial interest of all the parties in this room to the outcome or the process in this courtroom.
Mr. Wright, your motion that you filed implicating corpus delicti, which I read to be pertaining to your challenge of facts and circumstances constituting an alleged breach of law, I recognize that the matter was bound over from county court to district court on June 18, 2025. In light of the charges, I don't see that you had an opportunity for a preliminary hearing. The court does not have to go through a probable cause determination other than what's afforded by law. And when there's an opportunity for a preliminary hearing, your motion I read to be one in which there is challenge of probable cause. I previously denied that request based on your plea of not guilty, your challenge that there's insufficient law.
Look, I didn't plead not guilty.
Mr. Wright?
You entered that plea for me.
Mr. Wright, you're interrupting me, sir.
From the bench.
Mr. Wright, you interrupted me and I'm going to finish talking. First of all, you asked me why I had not given you a hearing on that motion. That motion I ruled on. I don't find anything further that requires a presentation of evidence or further hearing. I gave you until November 12 to file any additional motions. None were filed. Today we're set for that motions hearing. Mr. Wright, I've given you that opportunity. As far as your not guilty plea, I'm not going to cause delay waiting on you to enter yourself a plea of not guilty, so I entered it on your behalf, which is the option preserving your constitutional rights if you do not enter a plea of guilty. So that's why I've done
attention to anybody's constitutional rights, and you don't try the law and you don't try the facts.
Prosecutors confirm a plea offer was extended and rejected. The judge double-checks that the defendant truly wants trial instead of the deal. Instead of a clear answer, the defendant hints at questions, steering toward confrontation. The court reminds him this isn't negotiation hour. Now, this is procedure. You can almost hear the record scratch moment as the courtroom energy shifts from polite to pressure cooker.
Right. We don't have a jury trial. Today is not the jury trial in which we are going to try the facts. Now, Mr. Wright, I'm going to give Ms. Rains an opportunity to explain what the plea offer is. And Ms. Rains, if as part of the Lafler-Frye, you wish to go through the present 8 charges in which the court has entered a plea of not guilty on behalf of Mr. Wright, discussing what the possible penalties are, the court would accept that as part of the record. Mr. Wright, do you have something to write with?
Yes.
All right. If you wish to take notes of this, I'm going to ask if you've heard, understood this. This is giving some context of whether or not you understand there was a plea offer, possible consequences, and if you wish to then not accept that offer, which you do not have to take, and you certainly do have a right to a trial, including a jury trial.
I don't accept the offer.
I understand. That is very clear, but I need to make sure as part of the record what the offer is, because I don't know what it is, and we're going to make a record for your benefit what that offer is that you're declining.
So this is a court of record.
Ms. Rains.
Yes, Your Honor. I will go through the original 8 charges first. As to both counts 1 and 2, they are both Class 5 felonies. They carry the possibility of up to 1 to 3 years in the Department of Corrections. There are also probation-eligible offenses. Count 3 is a traffic 2 offense that carries a possibility of jail from 10 to 90 days or a fine of $150 to $300 or both. Driving under the restraint is a traffic infraction A. It carries a possibility of a fine between $15 and $100. Count 5 is a traffic infraction B that carries the same possible penalty as count 4. Count 6 is also a traffic infraction B, so same possible penalties as the 2 previous there. No insurance is also it's a traffic 1, so it carries a possibility of jail from 10 days to 1 year or a fine of $300 to $1,000 or both fine and imprisonment. And count 8 is a traffic infraction A, which again carries a fine of no less than $15 but up to $100. The plea offer that was extended to Mr. Wright in this case contained 2 charges that he would have pled guilty to. One was a defective vehicle, which was a traffic infraction A, so a fine of between $15 and $100, as well as a plea to a misdemeanor 1, possession of an illegal weapon, which carries the possibility of up to 364 days in jail or up to a $1,000 fine or both. That plea would have required Mr. Wright to forfeit the weapons that law enforcement discovered during their investigation. And part of the agreement was that I would not have objected to a probationary sentence.
The defendant claims he never received a fair hearing and raises concerns about financial interest in the courtroom. The judge explains that the motion challenged probable cause and was already denied. When the defendant insists he never entered a plea, the judge clarifies it was entered on his behalf to preserve his rights. Translation: the legal system keeps moving whether you consent or not. No pause button here.
And it's come to my knowledge that there could be financial interest in the process of this court, of each of the individuals in this court.
Mr. Wright.
That's a conflict of interest.
Mr. Wright, anything else, sir?
No. Does the prosecutor make any verified claim under penalty of perjury?
So to the extent that there was any request under Rule 97, the court does not self-recuse. The court does not recuse based on the oral request, suggesting that the court has any personal interest in the outcome of this matter. It does not. The court has no association with the parties or the outcome of this matter other than that of one of a professional association as disclosed in these proceedings. We currently are set for trial to begin January 14. It's a 3-day trial with all times beginning at 8 o'clock. Mr. Wright, I'll give you the same courtesy and opportunity, but I'll ask Ms. Rains first. Ms. Rains, anything further for the record on behalf of the people?
No, thank you.
Mr. Wright, there are certain things that you are saying that I don't fully understand. It may be that you have some questions of Ms. Rains that you may wish to discuss in person by way of email or otherwise. Mr. Wright, anything further, sir?
Is the prosecutor making a verified claim under the penalty of perjury?
The court recognizes the complaint and information that was filed May 28, 2025, supported with the affidavit in support of warrantless arrest that was filed May 23, 2025. The court has read that. While there was not opportunity for a preliminary hearing, as Mr. Wright was out of custody, the matter was bound over. The court has no obligation to conduct a probable cause determination In reviewing the affidavit in support of warrantless arrest, the court does not have concern as to probable cause in review of the affidavit in support of warrantless arrest, which the court finds to be sufficient in light of the charges. Mr. Wright, I'm trying to be quite generous with you to make record. Anything else, sir?
Prosecutors carefully outline all 8 charges: 2 felony counts with possible prison time, multiple traffic offenses, fines, and potential jail exposure. Then comes the plea deal, reduced to 1 traffic infraction and 1 misdemeanor, no objection to probation, and forfeiture of weapons. In short, a major legal discount. Yet the defendant declines choosing the full courtroom boss battle instead of the easy exit.
No? All right. With that, we'll continue with trial. Mr. Wright, you continue if you wish. An option that you have is to obtain counsel. There is time. Our jury trial is set for January 14 at 8 o'clock right back here. Counsel, what I would like to address are some pretrial issues that I think it may be best to just address now rather than conducting another appearance unnecessarily. In respect for Mr. Wright's time, and I recognize he has to then come into court every time we have a hearing. Ms. Raines may be in the vicinity already, so trying to consider Mr. Wright's availability as well. Let me print this out just briefly for my note-taking benefit, and then I'll address some things about trial and what that will look like. Mr. Wright, Ms. Raines, I'll have you out here shortly, and I also recognize because I went late on another matter, we got a late start, and that was no one's fault but mine. My apologies to you. So we're set for a 3-day trial. Either of you have any reason to believe that we'll need less time than that?
I think that's a safe estimate based on the nature of the issues that may arise during trial. But evidence-wise, I expect we could likely conclude evidence on day 1, at least from the prosecution side.
Okay. Mr. Wright, any opinion that you wish to share? What we'll do is then, Mr. Wright. Yes, sir.
I have the right to a trial by jury.
And you have preserved that, and so what we are contemplating fully is that you are interrupting me, sir, which is not permitted. And so we will be prepared to proceed with a jury trial on January 14, as you've requested. Yes, sir. Let's talk about time limitations, voir dire, which is the jury selection process.
Excuse me, I didn't say that.
Mr. Wright,
I'll say jury trial. I said trial by a jury.
Okay.
That means without a judge.
When asked directly, the defendant formally rejects the plea and claims he does not consent to the court's authority. The judge responds plainly, consent is not required. The court denies any conflict of interest claims and confirms trial scheduling. The warrantless arrest affidavit is reviewed and deemed sufficient for probable cause. Translation: the paperwork checks out, the train is leaving the station, and the courtroom stays undefeated.
That request is denied. So let's talk about voir dire and jury selection. So voir dire, the process, we will have 25 minutes for voir dire with 2 minutes for replacement. And let me explain what that is, recognizing Mr. Wright is representing himself. So in the jury selection process, what we'll do is we'll have one alternate. We'll have 25 people in and in front of the jury box, those people seated in seats 1 through 13 will be the presumptive jurors that will be selected. The person seated in seat 13 will be the alternate. No one is to inform any prospective jurors or jurors that there is an alternate or who that is. What we'll do is the court will conduct a voir dire, a jury selection, to make sure that there's no one who is by law not permitted to serve as a juror present. Both sides will have 25 minutes to ask questions of the prospective jurors. If there's anyone that is excused for cause, meaning that there is an extreme hardship or that they don't qualify, then there'll be need to replace those people from someone in the back of the courtroom, a prospective juror who has answered their summons. And so by replacement voir dire, that's what I'm talking about. And each side will have 2 minutes to ask questions. To be clear, jury selection will be based on, questions permitted will pertain to the appropriateness of a prospective juror to serve, their ability to follow the law, and to be objective. The court will limit opening statements to 15 minutes and closing arguments to 20 minutes. If anyone needs any parties, attorneys, witnesses, need any interpreters or Americans with Disability Act accommodations, I'm requiring that at least 21 days prior to trial that you notify me of that so I can find appropriate accommodation.
The judge confirms a 3-day jury trial, explains jury selection logistics, and reminds the defendant he may obtain counsel. Despite interruptions and sovereign-style objections, the schedule stands firm. The courtroom moves forward, calmly, methodically, and by the book. Final takeaway: when internet theories collide with real-world law, the law doesn't blink. Stay tuned. The trial promises fireworks, facts, and maybe a few more viral moments.
I'll require the people and Mr. Wright to both submit to the court and file a list of possible witnesses that may be called, because I will ask of the prospective jurors if they're familiar with anyone in the courtroom, including me, you, any of the possible witnesses. And to ask that, I need to have a list of your possible witnesses. So I'll want that 21 days prior to trial. Ms. Raines, and I'll ask Mr. Wright the same question. Do you have a request as to the old or new reasonable doubt instruction?
The people would request the new reasonable doubt instruction.
Mr. Wright, do you have any position on that? The Supreme Court has recently updated the reasonable doubt instruction. There is an old one we refer to. There is the new one now. Do you have an opinion as to using the old or new one, which would ultimately be the instruction to the jury as to what reasonable doubt is?
I would have to understand what they are.
What I will do is order that the new is to be used, subject to Mr. Wright timely presenting to the court any request to the contrary. That will need to be filed at least 21 days prior to trial.
Where do I find this new definition?
So you can go to the court. Do you know about the Court Resource Center, Mr. Wright?
Mm-hmm.
I didn't understand if that was a yes or no.
Yes.
Yes. If you go there, while they can't give you legal advice, they may be able to point you in the direction of obtaining what that is.
You change the definition of probable cause?
No. Ms. Raines, would you agree that this is instruction on Col G? I've got E3. I was going to just print this out for Mr. Wright as a courtesy so that he could easily then see what the current one is and what the old one was. So, Mr. Wright, I'm going to print this out for you and give this to you so you can read this.
I appreciate that.
Yes, sir. I got to be careful not to give you legal advice, but this is part of the discussion.
It's in writing.
Mr. Wright, we'll ask the judicial assistant to give this to you. Thank you, Ms. Organ. Thank you, Mr. Wright. So 21 days before trial, if there's any objection to using the new Mr. Wright, I'll receive any request. As far as live streaming, so Mr. Wright, one thing that we have going on right now is that we've got WebEx up. You can see that, but our legislature requires that in criminal cases, unless there are certain exceptions, that we also live stream, which we're doing right now, so that people can log in and watch these proceedings, and we don't even know who they are. Ms. Raines, is there any objection to the use of live streaming beginning at the time of the opening statement and throughout the parties' presentations of evidence?
No objection.
Mr. Wright, do you have any reason to object to that?
No, I insist on it.
Okay, then we'll certainly use that. We'll have jury instructions due at least 7 days prior to trial. Mr. Wright, you may present, if you want, a theory of defense instruction that I would contemplate and determine, as I would the people's proposed jury instructions, whether or not it's appropriate to present to the jury. And so if you wish to do that, you may submit that to the court as well. Also, within 7 days prior to jury trial. Mr. Wright, I'll let you know that because you do have the right to remain silent and that you don't have to disclose specifically your trial strategy, if you wish to submit that theory of defense and not submit it to the people, I'd consider receiving that, what we call ex parte, without the people receiving that for my contemplation, so that I could consider whether or not it might be something appropriate to ultimately go to the jury summarizing your theory of defense. It is not a requirement. You don't have to do it, but that's something that you may wish to do. That would take care of the pretrial conference, pretrial readiness. I would propose that we not have another hearing unless it's necessary or one is requested before January 14, Ms. Raines.
I'm sorry, can the court repeat that?
Yeah, any need for a pretrial conference, pretrial readiness conference before?
I don't have any need. If there is any, I guess, continuance issues that would arise on our end, the people can file a motion with the court.
Okay. Mr. Wright, the next court date is January 14. That's the date for jury trial. Is there any need for a setting prior to that?
I don't see one at the present.
All right. You, as Ms. Raines, may file a motion if there's any need to, stating what you're requesting and why. What I've done is tried to address these things about jury selection today so that you don't have to come into court today and to help reduce the number of times you have to appear. But if there is something that I need to take up with you all, I certainly will. Ms. Raines, Mr. Wright, good luck. I'm going to excuse myself. If you do wish to stay and talk, you may. If you wish to be excused, you certainly may as well. With that, parties are excused, and the court has recognized we have passed the court's plea cutoff deadline, so the court has every expectation that we will be going to trial.